Hello, and welcome. This is the Sleepy Solicitor, and tonight we journey into one of the longest, most labyrinthine legal cases in history, a case so endless, so monumentally tedious, that it consumed over a century, bankrupted hundreds of claimants, and inspired Charles Dickens to write one of literature's great satires of the legal system. This is the story of Jennings versus Jennings, though it was known by many names over its lifetime. It is a story without heroes, without villains, only the slow, inexorable grinding of bureaucratic machinery, the turning of legal wheels that ground so slowly they eventually ground themselves to dust. Settle in. Get comfortable. This will take some time, just as the case itself did. Let us begin in the year 1798, in a village called Acton, not far from London. The autumn air is cold. The leaves have turned brown and fallen. In a large house on the edge of the village lives a man named William Jennings, though some records call him William Jennings. The spelling of his name is uncertain, a detail that will become important later, as everything becomes important when lawyers are involved. William Jennings is dying. He is 97 years old, an extraordinary age for the 18th century. He has lived through the reigns of 5 British monarchs. He was born when Queen Anne sat on the throne. He has seen the Hanoverian succession, the Jacobite rebellions, the loss of the American colonies, the French Revolution. The world has changed around him, but William Jennings has remained much the same, solitary, suspicious, accumulating wealth. His house is dark. He keeps few candles lit, for candles cost money. The rooms are cold, for coal costs money. His servants, the few he employs, move quietly through the halls, speaking in whispers. Jennings does not like noise. He does not like company. He does not like spending. William Jennings is, by the standards of his day, fantastically wealthy. His fortune comes from land, acres and acres of property in Warwickshire, in Staffordshire, estates that generate rents from hundreds of tenants. These properties have been in his family for generations, accumulated carefully, added to methodically, never sold, always growing. The rents flow in like a slow river, filling his coffers year after year. But to look at William Jennings, you would never know he was rich. He dresses plainly, in old-fashioned clothes that have been mended and remended. He eats simple food. He lives alone in this big house, surrounded by his wealth but touching none of its comforts. He is a miser in the classic sense, not merely frugal, but pathologically unable to spend money, even on himself. Why? The historical record does not tell us. Perhaps he fears poverty, though he has never been poor. Perhaps he simply loves the accumulation of wealth for its own sake, the way some men love art or music. Perhaps long life has made him cynical, convinced that everyone wants to steal from him, that trust is for fools. Whatever the reason, William Jennings has spent his 97 years gathering money and refusing to let it go. He has never married. He has no children. His closest relatives are distant, cousins, nephews, and nieces he barely knows, the children and grandchildren of siblings long dead. They visit sometimes, these relatives, making the journey to Acton, sitting in his cold parlor, making awkward conversation with this ancient man who says little and gives nothing. Some of them hope, of course. They hope that when old William dies, some portion of his great wealth will come to them. They are not mercenary, exactly, or not all of them are, but neither are they unaware of the fortune that will need to go somewhere when the old man finally passes. William Jennings knows they hope. He is not a fool. He sees how they look at him, calculating his years, wondering how much longer the old man can last. It amuses him, in a bitter way. Or perhaps it simply confirms his suspicions about human nature. As autumn deepens into early winter in 1798, William Jennings feels death approaching. His body, which has served him for nearly a century, is finally failing. He spends his days in his study, a room lined with ledgers and account books, the careful records of decades of income and expenditure. On his desk sits a document. It is a will. His last will and testament, prepared by lawyers, setting out what should happen to his vast fortune after his death. The will is written in the formal legal language of the time, full of whereases and herebys and in witness whereofs. It runs to many pages, disposing of properties, setting up trusts, naming executors. But there is a problem. The will is not signed. We do not know why William Jennings never signed his will. Perhaps he meant to and kept putting it off, and death came too soon. Perhaps he changed his mind about its provisions and was waiting for his lawyers to draft a new version. Perhaps, in his final days, his hand was too weak to hold a pen. Perhaps he simply could not bring himself to make that final commitment, to let go of control even in death. Whatever the reason, when William Jennings dies in December of 1798, his will remains unsigned, invalid, worthless. All those careful provisions, all that legal language, meaningless. As far as the law is concerned, William Jennings died intestate, without a will. And when someone dies intestate with a large fortune and no obvious heirs, the law steps in. The Court of Chancery steps in. And once the Court of Chancery takes an interest in something, it does not let go quickly. The stage is set for one of the longest legal cases in British history. Before we proceed with our story, let us pause to understand what intestacy means. What happens when someone dies without a valid will? This understanding will help us appreciate why the Jennings case became such a nightmare. In English law, when a person dies testate, with a valid will, their property is distributed according to their wishes, as expressed in the will. The will names executors who are responsible for carrying out its provisions. The process is relatively straightforward, assuming the will is clear and properly executed. But when a person dies intestate, without a valid will, the law provides a default system for distributing their property. This system is based on family relationships. The property goes to the deceased's closest relatives according to a hierarchy established by statute and common law. First in line are children. If the deceased had children, they inherit. If some children have died, their children, the grandchildren of the deceased, take their parents' share. And so on down the generations. If there are no descendants, the property goes to the deceased's parents, if they're still alive. If not, to siblings. If siblings have died, to their children. Then to more distant relatives, aunts, uncles, cousins of various degrees. The law has an order, a progression from close family to more distant family. In theory, this system ensures that property stays in the family and goes to those with the closest blood connection to the deceased. But what happens when the family tree is complicated? What happens when there are many potential claimants, all asserting their right? What happens when the relationships are distant and the evidence is sparse? What happens is litigation. Long, expensive, exhausting litigation. For William Jennings, the situation was particularly complex. He had no children, no siblings still living, no parents. His closest relatives were nephews and nieces, and the children of nephews and nieces. But which ones? How many? Who exactly were they? The Jennings family, like many families, had branched and spread over generations. There were Jenningses, or Jenenses, scattered across England. Some had emigrated to Ireland, to America, to other parts of the British Empire. They had married, had children, those children had married and had children. The family tree had grown complex, tangled, difficult to trace. And every single one of these distant relatives, if they could prove their relationship to William Jennings, had a potential claim to a share of his fortune. Under the law of intestacy, they were all entitled heirs. The fortune would be divided among them according to their degree of relationship. Those more closely related would receive larger shares, those more distantly related would receive smaller shares. But first, they had to prove their relationship. They had to establish, with legal certainty, that they were indeed descended from the Jennings family, that their connection to William was genuine and documentable. This is where the real trouble began. News of William Jennings's death spread slowly at first. In the winter of 1798–99, Britain is at war with France. The newspapers are full of military news, political debates, concerns about invasion. The death of an elderly miser in Acton is not front-page material. But within the family, within that spreading network of cousins and distant relations, the news travels. William Jennings is dead. William Jennings, the rich one, the one who owned all that land. And he died without a will. The first claimants to come forward are the obvious ones, the nephews and nieces who had visited him occasionally, who knew him personally. They have the advantage of proximity and recognition. They can say, "I am Mary Jennings, daughter of his late brother Robert." Or, "I am Thomas Jennings, son of his late sister Elizabeth." These first claimants seem straightforward. They have relationships that are known, that were acknowledged by William during his lifetime. Surely they will inherit? Surely the matter will be settled quickly? But the law does not work quickly, especially in the Court of Chancery. The Court of Chancery in the late 18th and early 19th centuries is a unique institution. It is not like a modern court. It does not primarily concern itself with trials, with witnesses giving testimony, with juries rendering verdicts. The Court of Chancery is a court of equity, concerned with fairness and with property, and it operates through a system of written pleadings and documentary evidence that can stretch on for years, for decades. To make a claim in the Court of Chancery, one must file a bill in Chancery, a formal legal document setting out the facts of your case and the relief you seek. This bill must be drafted by a lawyer, and it must follow precise formal requirements. It must be served on all other parties who might have an interest in the case. Those other parties then file answers, their responses to your bill, agreeing with some parts, disputing others, perhaps making their own claims. There may be replications, responses to the answers. There may be rejoinders, responses to the replications. Each of these documents must be formally filed, properly served, carefully preserved in the court's records. And this is just the beginning of the process. The Court of Chancery also requires proof, documentary proof. You cannot simply walk into court and say, "I am William Jennings's nephew." You must prove it. You must produce baptismal records showing your birth. You must produce marriage records showing your parents' marriage. You must produce death certificates, parish registers, family Bibles, anything that documents your relationship. And if your claim depends on someone who died 50 years ago, you must produce records from 50 years ago. If it depends on a marriage that took place in a small parish in rural Warwickshire in 1720, you must find the register from that parish and produce a certified copy. This takes time. This takes money. This takes lawyers and clerks and searchers digging through dusty parish records and old probate files. The first claimants begin this process. They hire lawyers, solicitors to handle the paperwork, barristers to argue in court. They pay fees, court fees, lawyers' fees, fees for copying documents, fees for sending messages. The bills accumulate. And then, as word spreads further, more claimants appear. By 1800, dozens of people have come forward claiming to be heirs of William Jennings. By 1810, there are over 100 claimants. By 1820, several hundred. By the time the case finally ends, over a century later, there will have been thousands. Where do they all come from? How can one man have thousands of potential heirs? The answer lies in the mathematics of genealogy. Each person has two parents. Those parents each had two parents. Go back a few generations and the number of ancestors grows exponentially. Conversely, go forward from an ancestor and the number of descendants grows exponentially. William Jennings's grandparents, for example, might have had 6 or 8 children. Each of those children might have had 6 or 8 children. Those children might have had children. Within 3 or 4 generations, you could easily have hundreds of descendants. And not all these descendants stayed in England. The 18th century is an age of emigration. Younger sons without inheritances seek their fortunes in the colonies, in America, in the West Indies, in India. They marry there, have children there. Those children might grow up knowing little about their English ancestry except family stories, vague memories, names written in the front of Bibles. When news reaches them, perhaps years or decades after William Jennings's death, that there is a fortune to be claimed in England, that anyone who can prove descent from the Jennings family might be entitled to a share, they begin to investigate. They dig through their family papers. They write to relatives in England. They hire lawyers. Many of these claims are speculative. The claimants know they have some connection to the name Jennings, but are not sure exactly what it is. They hope that with enough research, enough documentation, they can establish a valid claim. The lawyers are happy to help. Working on the Jennings case becomes a specialized practice. There are lawyers in London who focus almost exclusively on Jennings claims. They advertise in newspapers, inviting anyone with a connection to the Jennings family to come forward. They work on contingency. If the claim succeeds, they take a percentage of the inheritance. This creates perverse incentives. The lawyers have reason to encourage even dubious claims, to keep the litigation going, to file endless documents and motions. The longer the case continues, the more fees they can collect. And the Court of Chancery, moving at its own measured pace, allows all of this. Every claim must be investigated. Every claimant must have their day in court, or at least their bill properly filed and considered. Justice, the court believes, requires thoroughness. Better to take a long time and get it right than to move quickly and make a mistake. But thoroughness, in this case, means taking decades. It means the case becoming legendary, infamous, a byword for legal delay and frustration. Let us slow down and consider in detail what these genealogical investigations involved. This is where the case becomes truly soporific, truly perfect for our purposes. The repetitive, meticulous, mind-numbing detail of tracing family lines. Consider a typical claimant, let us call him John Jennings, living in Philadelphia in 1815. John has heard, through family connections, that there is money to be claimed in England. His grandfather, he knows, came from England, from somewhere in the Midlands. The grandfather's name was also John Jennings. Beyond that, John knows little. But John is determined. He hires a lawyer in Philadelphia who has connections to lawyers in London. The Philadelphia lawyer writes to the London lawyer, explaining John's situation and asking for help investigating his claim. The London lawyer begins by checking the existing records in the Chancery case. By 1815, these records fill several rooms. There are thousands of pages of documents, bills, answers, affidavits, genealogical charts, copies of parish registers. The lawyer must read through these documents, or pay a clerk to read through them, looking for any mention of John Jennings the grandfather. Perhaps they find a reference. Perhaps they find that another claimant has mentioned a John Jennings who emigrated to America around 1760. This is promising. But it is not proof. The lawyer must now trace the grandfather's origins. If he emigrated in 1760, where did he come from? The lawyer writes to parishes in Warwickshire, in Staffordshire, in the counties where the Jennings family had properties. He asks to search their registers. Each parish charges a fee for this service. Each parish must be contacted separately. In 1815, this means letters carried by post, taking days or weeks to arrive, then days or weeks for a response. Let us say the lawyer finds a John Jennings baptized in the parish of Solihull in 1735. This might be the right John Jennings. But how to be certain? There might have been multiple John Jenningses in Solihull. The name is not uncommon. The lawyer looks for more evidence. Marriage records, death records, property transactions. Anything that might confirm this John Jennings of Solihull is the same John Jennings who went to America. Perhaps they find a marriage record. John Jennings married Mary Smith in Solihull in 1758. Do the dates make sense? If he married in 1758 and emigrated in 1760, that fits. Did he marry Mary Smith? John in Philadelphia can check with his own family records. Yes, his grandmother's name was Mary. Her maiden name was, he's not sure. The family doesn't remember. There might be something written in an old Bible somewhere. John writes to his cousins, his aunts, anyone who might have family documents. One cousin has a Bible with births recorded. Yes, Mary's maiden name was Smith. Another piece of the puzzle. But the investigation must go further. The lawyer must prove that this John Jennings of Solihull, married to Mary Smith, was himself descended from the Jennings family, specifically from an ancestor who was related to William Jennings. This means tracing John's parents. Who were they? The baptismal record should name them. Yes, here it is, John Jennings, son of Thomas Jennings and Anne Jennings. Good. Now the lawyer must find Thomas Jennings's baptismal record. And Anne's. And prove that Thomas was the son of someone, who was the son of someone else, eventually connecting back to a common ancestor with William Jennings. This could mean going back 4, 5, 6 generations. Each generation requires multiple documents, baptisms, marriages, burials. Each document must be found in a parish register somewhere in England. Each must be copied and certified by the parish clerk. Each certification costs money. The process can take years. And this is for just one claimant. There are hundreds of claimants, each requiring similar investigations. Imagine the work involved. Imagine the piles of letters, the stacks of certified copies, the genealogical charts growing more and more complex, branches splitting and splitting again, names repeating across generations, John after John after John, Mary after Mary after Mary, making it fiendishly difficult to keep track of who is who. And the name itself causes problems. Is it Jennings or Jennens? Parish records show both spellings. Sometimes the same family uses both spellings. Sometimes a record says Jennings with one N. Sometimes Jennings. Sometimes Jennings with a G. Are these all the same family? Or different families? The lawyers argue about this. Some claim that only Jennens with an E and 2 N's is the true family name. Others argue that spelling was fluid in earlier centuries and all variations should be accepted. The court must decide. The court asks for more evidence, more investigations, more certified copies of parish registers showing how the name was spelled at different times and places. The case grows. The documents multiply. The years pass. Let us now consider the Court of Chancery itself, the institution that presided over this case for over a century. Understanding the court helps us understand why the case took so long. The Court of Chancery is one of the ancient courts of England. It developed in the medieval period as the court of the Lord Chancellor, who was originally the King's secretary. Over time, it became a court that dealt with matters of equity and conscience, cases where the rigid rules of the common law seemed unfair or inadequate. By the late 18th century, the Court of Chancery has jurisdiction over trusts, estates, property disputes, and other complex matters. It is supposed to provide justice where the common law courts cannot. But it has developed severe problems. The first problem is its procedure. Everything in Chancery must be done in writing. There are no jury trials, no witnesses giving oral testimony in a courtroom. Instead, everything proceeds through written documents filed with the court. These documents are not simple. They are drafted in a formal, arcane style, full of legal jargon and ritualistic phrases. A simple statement that might take one sentence in plain English requires a paragraph in Chancery prose, with proper invocations and formal structures. Moreover, these documents must be written on parchment, not paper, and they must be written in a particular format with specific margins and spacing. Clerks are employed to do this work, and they charge by the page. The longer a document is, the more they earn. This creates an incentive to be verbose, to use 3 words where 1 would do, to stretch out documents unnecessarily. Every document filed generates more documents. A bill requires an answer. An answer may provoke a replication. A replication may generate a rejoinder. Each document must be formally filed, properly served on all parties, copied for the court's records. Each step takes time and money. The second problem is the court's schedule. The Court of Chancery sits during certain terms of the year, with long vacations in between. During these vacations, nothing happens. Cases simply wait. If your case is not reached during a particular term, it waits until the next term. Months pass in idleness. The third problem is personnel. The Lord Chancellor, who theoretically heads the court, is a political appointee, a member of the government. He has many responsibilities beyond hearing chancery cases. He may spend much of his time in Parliament or on government business. The actual work of hearing cases falls to the Master of the Rolls and to the Vice-Chancellors, but there are far too many cases for them to handle efficiently. Cases therefore accumulate. By the early 19th century, there are thousands of cases pending in Chancery, some of them decades old. The court hears a few cases at a time, slowly working through its docket, but new cases arrive faster than old ones are resolved. The fourth problem is the court's approach to evidence and decision-making. The court is extremely cautious. It wants to be absolutely certain before making any decision. If there is any doubt, any ambiguity, any missing piece of evidence, the court will ask for more information, order further investigations, delay its decision. This caution, combined with the complexity of cases like Jennings, where there are hundreds of parties and thousands of documents, means that decisions can take years. The court might spend months just reading the documents filed by various parties. Then it might order further inquiries. Then more documents will be filed. Then more reading. Then perhaps a hearing, where lawyers argue for hours or days. Then the court takes time to consider. Then eventually, maybe, a decision. And if anyone is unhappy with the decision, they can appeal, starting much of the process over again. Charles Dickens, who worked as a law clerk in his youth and saw the Court of Chancery up close, was horrified by its inefficiency and inhumanity. In his novel Bleak House, published in 1852-53, he depicted a case called Jarndyce and Jarndyce that has been in Chancery for generations, consuming the estate it concerns, ruining the lives of everyone connected to it. Dickens based Jarndyce and Jarndyce directly on the Jennings case. The parallels are clear. Both cases involve contested estates. Both drag on for decades. Both consume the money they're fighting over in legal fees. Both become legendary examples of Chancery's failure. Dickens writes, Jarndyce and Jarndyce drones on. This scarecrow of a suit has, in course of time, become so complicated that no man alive knows what it means. The parties to it understand it least, but it has been observed that no two Chancery lawyers can talk about it for 5 minutes without coming to a total disagreement as to all the premises. This is Jennings versus Jennings. This is the reality that inspired Dickens's satire. As the years pass, as the case continues, a disturbing pattern emerges. The fortune that everyone is fighting over is shrinking. William Jennings died with an estate worth perhaps £2 million in the money of his day, a staggering sum, equivalent to perhaps £200 million or more in modern currency. The estate consists primarily of land, which generates rental income, but there is also money in various investments, bonds, and securities yielding returns. This income should be accumulating, growing the estate year by year. But instead, the estate is shrinking. Why? Legal fees. Every claimant has lawyers. Every lawyer charges fees. The solicitors charge for preparing documents, for correspondence, for attending to the case. The barristers charge for their opinions, for their appearances in court, for drafting legal arguments. The court charges fees for filing documents, for storing documents, for performing various administrative functions. And because the estate is in chancery, because it has not yet been distributed to any heir, these fees are paid from the estate itself. The court appoints administrators to manage the estate during the litigation. These administrators collect the rents, manage the properties, and pay the ongoing expenses, including the legal fees. Year by year, the legal fees mount. In the early years, they are manageable, a few £1,000s per year perhaps. But as the case grows more complex, as more claimants join, as more investigations are undertaken, the fees escalate. By 1820, the legal fees are consuming most of the estate's annual income. By 1840, they exceed it. The estate begins to dip into capital, selling investments to pay the lawyers. By 1860, significant properties have been sold. By 1880, the great estate that William Jennings accumulated so carefully over his 97 years has been substantially depleted. The lawyers, of course, are doing well. Working on the Jennings case becomes a lucrative specialty. Firms pass the work down from generation to generation, fathers to sons to grandsons. There are lawyers whose entire careers consist of nothing but Jennings matters. They become experts in the tangled genealogy, in the complex procedural history, in the thousands of documents that make up the case file. Some of these lawyers are honest, diligent professionals doing their best in a difficult situation. Others are more cynical, recognizing that the case is a golden goose that should not be killed too quickly. Why resolve the case when unresolved it generates steady income year after year? The claimants watch helplessly as the estate they're fighting over diminishes. They are trapped. If they give up their claims, they get nothing. If they continue, they must keep paying their own lawyers while watching the estate shrink. It's a slow-motion tragedy, visible to everyone involved but seemingly impossible to stop. The Court of Chancery, moving at its glacial pace, seems untroubled by this. The court's job is to ensure that the estate is properly distributed according to law. Speed is not a priority. The court will take whatever time is necessary to reach the correct decision. But the correct decision, when it finally comes, may be worthless if there is nothing left to distribute. Behind the legal documents, behind the genealogical charts and the procedural motions, there are human beings whose lives are shaped, defined, sometimes ruined by their connection to Jennings versus Jennings. Consider the professional claimants, people who build their entire lives around their claim to the Jennings fortune. They spend decades pursuing their case, paying lawyers, gathering evidence, waiting for the court to decide. They postpone other life decisions, believing that someday, when the case is resolved, they will be rich. They make plans for what they'll do with their inheritance. They borrow money against their expected windfall. But the case drags on. Years turn into decades. They grow old waiting. Some die before the case is resolved, passing their claim to their children, who pass it to their children. 3 generations of a family might be involved in the case, each believing that justice is just around the corner, that the next hearing will finally settle things. Consider the lawyers who dedicate their careers to the case. Some enter the profession excited about working on such a famous, important matter. They imagine they'll be the ones to finally untangle the case, to bring it to a successful conclusion. They'll make their reputation. But the case is too complex, too entrenched. No one lawyer can master all of it. The procedural history alone takes years to understand. The genealogical evidence is overwhelming. These lawyers spend their careers drowning in paper, their ambitions gradually eroded by the reality of chancery procedure. Some become bitter. They see how the case consumes everything: time, money, hope. They see how it enriches other lawyers while impoverishing the claimants. They want to get out but cannot. They have expertise no one else needs. They have invested too much time to walk away. They are trapped. Consider the court officials, the clerks and administrators who handle the day-to-day management of the case. For them, Jennings versus Jennings is just a job, but it's a job that never ends. There are always more documents to file, more copies to make, more letters to send. The case provides steady employment, but it's employment without satisfaction. Nothing is ever resolved. Nothing ever moves forward significantly. It's bureaucratic limbo. Consider the descendants of William Jennings who are not claimants, who for whatever reason did not join the case or whose claims were rejected early on. They watch from the outside as this spectacle unfolds. Perhaps they feel they should have tried harder, should have fought for their claim. Perhaps they feel relief that they're not involved. Perhaps they feel a strange mixture of emotions, frustration at missing out on potential wealth, satisfaction at avoiding the nightmare of litigation. Consider the communities where the Jennings properties are located. For over a century, these properties are in a kind of legal limbo. They cannot be sold or significantly improved because the ownership is uncertain. The administrators collect rents but do minimal maintenance. The properties gradually decline. Tenants complain but have no one to complain to effectively. The whole situation is frustrating for everyone except perhaps the lawyers. The case becomes legendary in British legal circles. It is discussed in law books, cited as an example of everything wrong with the Court of Chancery. Law reformers point to it when arguing for changes to the system. But the reforms come slowly, too slowly to save the Jennings case. As we move into the middle decades of the 19th century, the case continues its slow, grinding progress. But something changes in how we must narrate it. In the early years, we could identify specific developments, specific claimants, specific legal arguments. But as the decades pass, these specifics blur together. There is a hearing in 1835. What was it about? Some dispute over evidence, some claimants' documentation being challenged. The court asks for further proof. More time passes. There is a hearing in 1842. Another dispute. More evidence. The court reserves judgment. Months pass. A decision is issued. It resolves one small aspect of the case but leaves the main questions unanswered. There is a hearing in 1851. An 1858. An 1866. Each hearing addresses some piece of the larger puzzle. Each generates more documents, more fees, more delay. The original claimants from the 1800s and 1810s are dead now. Their children have taken over their claims. Some of these children have died too. Grandchildren are now prosecuting claims that their grandparents initiated. New claimants continue to appear. Someone in Australia discovers they have Jennings ancestry and files a claim. Someone in Canada. Someone in South Africa. The British Empire is global now, and Jennings' descendants have spread across it. Each new claim must be investigated, documented, litigated. The legal arguments have become extraordinarily technical. Lawyers debate fine points of inheritance law, of evidence law, of genealogical proof. They cite cases going back centuries. They analyze medieval statutes. They argue about Latin phrases and ancient legal principles. To an outsider, to anyone not deeply immersed in the case, these arguments are incomprehensible. They are debates about minutiae, about technicalities that have no apparent relevance to the fundamental question, who should inherit William Jennings's fortune? But in the logic of Chancery, these technicalities matter. The law must be followed precisely. Every detail must be correct. Justice requires thoroughness, even if thoroughness requires decades. The Court of Chancery itself undergoes reforms during this period. In 1873, the Judicature Acts reorganized the English court system. The Court of Chancery is abolished as a separate entity and merged into the High Court of Justice. Chancery becomes a division of the High Court rather than an independent court. These reforms are supposed to make the system more efficient, to reduce delays. And for new cases, perhaps they do. But for old cases like Jennings, cases with such extensive procedural history, such entrenched positions, the reforms make little practical difference. The case continues under the new system much as it did under the old. The estate continues to shrink. By 1880, it is perhaps one-third the size it was in 1800. By 1890, less than that. The great properties are being sold off piece by piece. The income that once flowed steadily is trickling now, barely enough to cover the ongoing legal fees. The claimants remain hopeful, or at least committed. They have invested too much to quit now. Surely the case must end soon. Surely the court will finally make a decision. Surely they will see some return on their decades of waiting and paying lawyers. But the case does not end. It continues. Through the Victorian era, through the Edwardian era, into the 20th century. Let us pause in our chronological narrative to examine in detail one thread of the genealogical evidence. This will give you a sense of the extraordinary complexity involved, the kind of detail that had to be worked through for hundreds of claimants. Consider the claim of one family, let us call them the Brookfield branch. Their claim rests on the assertion that their ancestor, Margaret Jennings, was a sister of William Jennings's grandfather. To prove this claim, they must establish several links in a chain. First, that Margaret Jennings existed and was born in approximately 1680. The evidence for this comes from a baptismal record in the parish register of St. Mary's Church, Solihull, dated March 15, 1680. The entry reads, "Margaret, daughter of Thomas Jennings and Elizabeth his wife." The handwriting is faded, the ink brown with age. A clerk in 1850 travels to Solihull, pays the parish a fee, and makes a certified copy of this entry. The copy is filed with the court, added to the thousands of other documents in the case. Second, that this Margaret Jennings married a man named Robert Brookfield in 1702. The evidence comes from another parish register, this time from the Church of St. Michael, Birmingham. The entry reads, "Robert Brookfield of this parish married to Margaret Jennings of Solihull, by licence, the 14th of June, 1702. Again, a clerk must travel to Birmingham, search through the registers, find this entry, make a certified copy. More fees. More paperwork. Third, that Margaret Jennings who married Robert Brookfield in 1702 is the same Margaret Jennings who was baptized in Solihull in 1680. This is more difficult. The marriage record identifies her as of Solihull, which suggests she's from Solihull, where the baptism occurred. The dates work. If she was born in 1680, she'd be 22 in 1702, a reasonable age for marriage. But is this enough? Could there have been two Margaret Jenningses in Solihull around the same time? The lawyers for the Brookfield claim search for other evidence. They find a will, the will of Thomas Jennings of Solihull, dated 1705. In this will, Thomas mentions my daughter Margaret Brookfield, wife of Robert Brookfield of Birmingham. This is good evidence. It confirms that Thomas Jennings had a daughter Margaret who married a Brookfield. But is this the same Thomas Jennings who appears in the 1680 baptismal record? The dates suggest it could be a man who had a daughter baptized in 1680 would likely still be alive in 1705. But the will doesn't give Thomas's age or any other details that would confirm his identity with certainty. More investigation is needed. The lawyers search for Thomas Jennings's baptismal record, his marriage record, any property transactions in his name, any other documentary evidence of his life. They find some records, but not all. Parish registers from the 17th century are incomplete. Some records were lost in fires, damaged by damp, simply not kept carefully. Fourth, that this Thomas Jennings, father of Margaret, was the brother of another Thomas Jennings who was William Jennings's grandfather. This is the crucial link, and it is the most difficult to prove. The claim is that there were two brothers, both named Thomas Jennings, both living in Warwickshire in the late 1600s. One brother's line leads to William Jennings. The other brother's line leads, through Margaret, to the Brookfield family. The evidence for this relationship is circumstantial. There are records showing 2 Thomas Jenningses in the area at the right time. There are property records suggesting they were related, they witnessed each other's documents, stood as godfathers to each other's children, the kind of things brothers might do. But there is no document that explicitly states Thomas Jennings and Thomas Jennings were brothers. No family Bible lists them both as sons of the same parents. No will mentions both brothers by name in a way that confirms their relationship. The lawyers for the Brookfield claim argue that the circumstantial evidence is sufficient. The 2 Thomas Jenningses clearly knew each other, clearly had some family connection. What else could explain their interactions? They must have been brothers, or perhaps cousins. But other claimants dispute this. They argue that the 2 Thomas Jenningses might have been unrelated, just 2 men with the same common name living in the same area. The circumstantial evidence is not enough. More proof is needed. The court, cautious as always, asks for more investigation. Are there other records that might shed light on this relationship? Church records? Manorial records? Court records? Tax records? Anything? The lawyers search. They spend months, years, combing through archives. They find fragments of information, a reference here, a mention there, but nothing definitive. The connection between the 2 Thomas Jenningses remains unproven to the standard the court requires. The Brookfield claim remains in limbo. Not rejected, but not accepted. Waiting for more evidence. Waiting for the court to decide if the evidence already gathered is sufficient. And this is just one claim, one branch of the family tree. There are hundreds of similar claims, each requiring similar investigations, each generating similar mountains of documentation, each creating similar uncertainty. Multiply this process by hundreds, and you begin to understand why the case takes so long, why it generates so much paperwork, why it consumes so much money. Let us consider more closely the lawyers who worked on Jennings versus Jennings over its long history. These lawyers are, in many ways, the true protagonists of our story, not the claimants, not the judges, but the lawyers who kept the case alive decade after decade. The first generation of lawyers, those who began work on the case in the early 1800s, approached it with energy and optimism. Here was a major estate case, involving significant wealth. Success would bring both money and professional reputation. They dove into the work enthusiastically. But as the years passed, as the case proved more intractable than anyone expected, that enthusiasm faded. The case became a burden, a monster that consumed time and resources without giving back resolution. Some lawyers gave up. They withdrew from the case, turned their attention to other matters that might actually be resolved within their lifetimes. The Jennings case, they realized, was a trap. But others stayed. They had invested too much time to quit. They had developed expertise in the case that was valuable, even if that expertise was narrowly specialized. And the case did generate fees, steady fees year after year. It might not make them rich, but it provided income. These lawyers passed the case to their successors. A solicitor who worked on Jennings matters for 30 years would bring his son into the firm, teach him the intricacies of the case, gradually hand over responsibility. The son would work on the case for 30 years, then pass it to his son. By the late 19th century, there were law firms where working on the Jennings case was a family tradition spanning 3 or 4 generations. The current solicitor's great-grandfather had been involved in the case. Family legend held that the great-grandfather had believed the case would be resolved any day now. 70 years later, the great-grandson knew better. These lawyers developed a peculiar relationship with the case. It was frustrating, certainly. It was tedious. It required wading through endless documents, mastering minutiae, arguing about details that seemed to matter to no one outside the case. But it was also familiar, comfortable in its way. The case was always there, a constant in a changing world. the lawyers who worked on Jennings versus Jennings became specialists in a very particular kind of law: genealogical proof, evidence standards in inheritance cases, chancery procedure. This expertise was not widely applicable. You couldn't take skills honed on the Jennings case and easily apply them elsewhere. The case was sui generis, unique, in a category by itself. Some of these lawyers wrote about the case, published articles in law journals analyzing particular aspects of it, reflecting on what it revealed about the legal system. These articles have a melancholy tone. The lawyers recognize that the case is a disaster, a failure of justice, but they don't know how to fix it. They are caught in a system that has its own logic, its own momentum, and individual lawyers cannot change that system. Charles Dickens, in Bleak House, created memorable lawyer characters associated with the Jarndyce case. There is Mr. Tulkinghorn, the mysterious and sinister solicitor. There is Mr. Vholes, the vampiric lawyer who slowly drains his client of resources while professing concern for the client's welfare. There is Mr. Kenga, the pompous solicitor who speaks endlessly about the glories of chancery while accomplishing nothing. These characters, though exaggerated for literary effect, are based on the real lawyers Dickens observed working on cases like Jennings. They capture something true about how the case shaped the lawyers involved, making some cynical, some pompous, some simply exhausted. By the early 20th century, the lawyers still working on Jennings versus Jennings are few. Most of the original claims have been resolved or abandoned. The estate has shrunk to almost nothing. There is little left to fight over. But a few claims remain active, a few lawyers still file occasional motions, still attend the rare hearings that occur. These final lawyers are caretakers of a dying case, managing its decline, waiting for the inevitable end. As the 19th century turns into the 20th, the Jennings case becomes increasingly anachronistic. The world is changing rapidly: motorcars, electric lights, telephones, airplanes. The Victorian era gives way to the Edwardian era, then to the Georgian era. The First World War erupts and reshapes European civilization. But in the legal world, in the dusty files of what is now the Chancery Division of the High Court, Jennings versus Jennings continues, largely unchanged. It is a relic from another age, a case that should have been resolved generations ago but somehow persists. The lawyers and judges who encounter the case in the early 1900s regard it with a mixture of awe and disbelief. The case file, if assembled in one place, would fill a small room. The number of parties who have been involved over the decades runs into the thousands. The procedural history is so complex that no one person can hold it all in their mind. New cases that come before the court are resolved in months or a few years. The legal system has reformed, become more efficient. But the Jennings case, with its century of history, its entrenched positions, its depleted estate, cannot be easily resolved. It exists in a kind of legal limbo, too old to be efficiently processed, too complex to be quickly decided. The estate is now a shadow of its former self. Most of the properties have been sold. What remains generates barely enough income to cover the minimal ongoing administrative costs. There is certainly not enough to provide meaningful inheritances to the hundreds of claimants, even if their claims were all valid. The claimants still involved are mostly descendants of the original claimants, grandchildren, great-grandchildren. They continue the claims out of family loyalty, out of stubbornness, out of a vague hope that maybe, somehow, something will come of it. But few have much real expectation of receiving anything substantial. Some claimants have never even seen the document supporting their claims. The claims are managed by lawyers, passed down through generations of lawyers and claimants alike, taking on a life independent of the people they supposedly serve. In 1915, something happens that will finally end the case, though not in the way anyone expected. The First World War is raging. Britain is mobilized for total war. The legal system, like everything else, is affected. Courts focus on urgent wartime matters. Old civil cases receive less attention. In this context, the court finally acts decisively on Jennings versus Jennings. But the decision is not a resolution of who should inherit. The decision is that the case must end because there is nothing left to inherit. In 1915, the court orders a final accounting of the Jennings estate. What remains? What is there to distribute? The accountants go through the records. They tally the remaining properties, the remaining investments, the cash on hand. They calculate the income received over the past year. They list the expenses, ongoing legal fees, administrative costs, property maintenance. The result is sobering. The estate that was worth approximately £2 million in 1798 is now worth, in real terms, almost nothing. The legal fees and costs incurred over 117 years have consumed virtually everything. There are a few properties still held in the estate's name, but they are mortgaged. The rental income barely covers the mortgage payments and maintenance. The estate is, in effect, bankrupt. The court makes a decision. The remaining properties will be sold. The proceeds, after paying all outstanding debts and costs, will be distributed among the valid claimants, but the amount each claimant receives will be negligible, pounds or shillings rather than the thousands they might have hoped for. The valid claimants, those whose genealogical claims have been proven to the court's satisfaction over the years, number in the hundreds. When the small remaining estate is divided among them, each receives almost nothing. Some claimants have spent more on legal fees over the years than they will receive from the final distribution. They have lost money by pursuing their claims. Others break even, more or less. A few might receive slightly more than they spent, but not much more. The case is closed. Jennings vs. Jennings, which began in 1798 with William Jennings's death and his unsigned will, ends in 1915 with a whimper, not a bang. There is no dramatic final hearing, no climactic legal argument. There is simply an administrative decision that the estate is exhausted and the case must end. The lawyers file their final papers. The accountants prepare their final reports. The court issues its final orders. The case that was once legendary, that inspired Charles Dickens, that became a byword for legal delay and frustration, simply ends. The claimants receive letters informing them of the final distribution. Most accept the news with resignation. They had long since given up hope of any substantial inheritance. Some feel anger, bitterness at the waste of time and money. Some feel relief that it's finally over, that they or their descendants no longer need to think about the Jennings case. The lawyers move on to other matters. The court clerks file the final documents away. The case joins the archives, another piece of legal history, another cautionary tale about the dangers of litigation. And William Jennings's fortune, so carefully accumulated over 97 years, so jealously guarded, so pointlessly unsigned for in his will, that fortune has vanished, consumed by the very legal system meant to ensure its proper distribution. As we near the end of our journey through Jennings vs. Jennings, let us reflect on what this case reveals about law, about justice, about human nature. First, the case reveals the dangers of excessive proceduralism. The Court of Chancery was obsessed with procedure, with getting every detail right, with thoroughness at all costs. This obsession with process led to the destruction of the very thing the process was meant to protect. The estate was consumed by the effort to properly distribute it. There is a lesson here about law and justice. Process is important, we need rules and procedures to ensure fairness. But when process becomes an end in itself, when it loses sight of its purpose, it becomes destructive rather than protective. Second, the case reveals how economic incentives can pervert justice. The lawyers had an incentive to keep the case going. The longer it continued, the more fees they collected. Not all lawyers were cynical or greedy, but the structure of the system rewarded delay rather than resolution. Modern legal systems try to address this through various reforms, limits on fees, requirements for timely resolution, sanctions for unnecessary delay. But the fundamental problem remains: lawyers are paid for their time, which creates some incentive to take more time. Third, the case reveals the complexity of genealogical proof. In an age before modern record keeping, before birth certificates and social security numbers and comprehensive databases, proving family relationships was genuinely difficult. Parish registers were incomplete, memories were unreliable, documents were lost or damaged. We take for granted now that we can prove who we are, that we can document our family relationships. But in the 18th and 19th centuries, such proof was often impossible to provide with certainty. The Jennings case shows how this uncertainty could create endless disputes. Fourth, the case reveals something about hope and delusion. The claimants clung to hope year after year, decade after decade, even as the evidence mounted that they would never receive any substantial inheritance. This hope was not entirely irrational. After all, the estate really did exist, and they really might have valid claims. But it became a trap, preventing them from moving on with their lives. We see similar patterns today in various contexts: people who spend years fighting legal battles they are unlikely to win, people who chase after possibilities that are increasingly remote. The sunk cost fallacy, the tendency to continue investing in something because we've already invested so much, kept claimants in the Jennings case long past the point where rational calculation would have suggested giving up. Fifth, the case reveals how legal disputes can become self-perpetuating. Once the Jennings case reached a certain size and complexity, it became almost impossible to resolve. There were too many parties, too many claims, too much history. Any attempted resolution would immediately be challenged by parties who felt they were being treated unfairly. The case was stuck. This too has modern parallels. Complex litigation can take on a life of its own, becoming so complicated that resolution seems impossible. Sometimes the only way out is through some kind of collective settlement or, as with Jennings, through the complete exhaustion of the resources being fought over. Sixth, the case reveals the gap between law and justice. Legally, the Court of Chancery was doing its job, carefully considering evidence, applying legal standards, proceeding with appropriate caution. But the result was deeply unjust. A fortune was consumed, lives were wasted, and no one benefited except the lawyers. This suggests that justice requires not just correct legal reasoning but also practical wisdom, a sense of proportion, and understanding of how legal processes affect human lives. The Court of Chancery lacked these qualities, at least as it functioned in the 19th century. Finally, the case reveals something about time and mortality. All of the original participants in the case, William Jennings, the first claimants, the first lawyers, the first judges, died long before the case ended. The case outlived them all. It became something independent of any individual human life, a process that continued because it had its own momentum, not because anyone particularly wanted it to. This is both absurd and tragic. The case was meant to serve human purposes, to distribute property, to recognize family relationships, to ensure fairness. But it became detached from those purposes, becoming instead a monument to bureaucratic inertia. What is the legacy of this case? How is it remembered? What impact did it have? The most obvious legacy is Bleak House. Charles Dickens's novel, published in 1852 to 1853, brought the problems of the Court of Chancery to wide public attention. The novel was hugely popular and influential. It helped build public support for legal reform. The Judicature Acts of the 1870s, which reformed the English court system and abolished the Court of Chancery as a separate entity, were partly a response to the problems that Dickens highlighted. While the Jennings case itself wasn't saved by these reforms, countless future cases benefited from them. In legal education, Jennings versus Jennings is sometimes used as a case study in civil procedure courses or in discussions of legal ethics. It illustrates what can go wrong when process overwhelms substance, when the legal system loses sight of its purpose. In popular culture, the case is less well known than Bleak House, but it occasionally appears in discussions of famous legal cases or historical curiosities. It's the kind of story that seems almost unbelievable, a case that lasted over a century, that consumed the entire fortune it was fighting over. It sounds like an exaggeration, but it's not. For genealogists, The Jennings case is interesting because of the extensive family history research it generated. The various claimants produced detailed genealogical charts, traced family lines back many generations, gathered documents from parishes all over England. This research, preserved in the case files, can be valuable for anyone studying families with connections to the Jennings name. For lawyers and judges, the case is a cautionary tale. It represents the worst possible outcome of litigation. Everyone loses except the lawyers, and even they end up working on a case that becomes increasingly pointless as the years go by. The case also contributed to broader discussions about legal reform. In the 19th and early 20th centuries, there was extensive debate about how to make the legal system more efficient, more accessible, more responsive to the needs of ordinary people. The Jennings case was Exhibit A for the reformers, proof that the old system was broken beyond repair. Modern legal systems have learned some lessons from cases like Jennings. There are now rules about timely disposition of cases. Courts have case management powers, allowing judges to control litigation and prevent it from spiraling out of control. There are limits on discovery, limits on motions, mechanisms for early resolution of disputes. These reforms aren't perfect. Modern litigation can still be expensive and slow. But nothing like Jennings versus Jennings could happen today, at least not in well-functioning legal systems. The mechanisms exist to prevent it. Perhaps the deepest legacy of the case is philosophical. It reminds us that procedures and institutions, even those created with the best intentions, can become dysfunctional. It reminds us that law, if it loses sight of justice, becomes merely a game that lawyers play while real people suffer. It reminds us that complexity can be the enemy of fairness, that sometimes the simple, rough and ready solution is better than the theoretically perfect solution that takes a century to achieve. And it reminds us of the human capacity for hope, even irrational hope. The claimants who pursued the Jennings case generation after generation were not fools. They were ordinary people, believing that the system would eventually work, that justice would eventually be done, that their patience would eventually be rewarded. That their belief was disappointed is tragic, but the belief itself is deeply human. And so we come to the end of the Jennings case, and to the end of our story. The case that began with an old man dying in a cold house in 1798 ended 117 years later with a bureaucratic order distributing a few pounds among hundreds of claimants. There is no monument to the Jennings case, no memorial to William Jennings or the thousands of people whose lives were touched by the litigation. The properties that once made up his great estate have been sold, divided, redeveloped. The village of Acton where he lived has been absorbed into Greater London. The cold house where he died, if it still stands, is now just another old building, with no plaque to mark its significance. The case files, thousands upon thousands of pages of documents, sit in archives somewhere, gathering dust. Occasionally a legal historian might consult them, researching the history of chancery or the development of evidence law. But mostly they sit undisturbed, a paper monument to futility. The people involved, the claimants, the lawyers, the judges, are all long dead now. Most left no mark on history beyond their connection to this case. They lived their lives, pursued their claims or practiced their profession, and passed away, as all people do. William Jennings himself, the miser of Acton, achieved a kind of immortality through this case, but not the kind he might have wanted. He is remembered not for his business acumen, not for his careful accumulation of wealth, but for his failure to sign his will, for the chaos that his unsigned will created. Perhaps there is irony in that. Jennings spent his life obsessed with money, with accumulating and preserving wealth. He lived meanly to save every penny. And in the end, his wealth was destroyed by his own oversight, consumed by the very legal system meant to protect property rights. Or perhaps there is a kind of justice in it. Jennings hoarded his wealth, refused to spend it, refused to share it even with his own relatives. And so, in the end, no one benefited from it. The fortune that he could have used to bring comfort to himself or others simply vanished, as if it had never existed. The case teaches us, if it teaches us anything, about the importance of clarity, of decisiveness, of not leaving things undone. William Jennings could have signed his will. It would have taken a moment. But he didn't, and that moment of indecision led to a century of litigation. It teaches us about the dangers of systems that become ends in themselves, processes that lose sight of their purposes. The Court of Chancery was meant to do justice, but it became a machine for generating documents and consuming wealth. It teaches us about the human capacity for persistence, for hope, for clinging to the possibility of a better outcome even when all evidence suggests that outcome will never arrive. The claimants in the Jennings case were not foolish to pursue their claims, at least not initially. But they perhaps should have known when to quit, when to accept that some fights are not worth fighting. And it teaches us about time, about how slowly the wheels of bureaucracy can turn, about how lives can be consumed by processes that seem to exist outside of human time, operating according to their own logic, their own rhythm. As you drift towards sleep, imagine the documents slowly accumulating in those chancery files. Page after page, year after year, decade after decade. Imagine the lawyers writing their briefs, the clerks copying out the pleadings, the judges reading the evidence. Imagine the claimants waiting, always waiting, for a resolution that never quite arrives. Imagine time passing. Years turning into decades. Decades turning into a century. The world changing around the case, but the case itself unchanging, trapped in its own procedural amber. Imagine the estate slowly shrinking, sold off piece by piece to pay the legal fees, the great fortune evaporating like morning dew in sunlight, vanishing, vanishing, until nothing remains but documents, memories, stories. Imagine the final day in 1915 when the case officially ended. Perhaps it was a quiet day in court. Perhaps a clerk simply filed the final order and closed the file. Perhaps no one present even realized they were witnessing the end of something that had endured for over a century. The case is over. The story is told. The fortune is gone. The people are dead. All that remains is this tale, this cautionary story, this reminder of how things can go wrong when human institutions lose their way. Rest now. Let the story fade. Let the names and dates and legal details blur together and dissolve. Let yourself drift, like those documents gathering dust in their archive, peaceful and still, time suspended, worries released. The case took over a century to resolve. But your sleep will be quicker, gentler, more merciful. The wheels of justice ground slowly, grinding everything in their path. But sleep comes without grinding, without friction, a soft descent into rest. William Jennings's will remained unsigned, and chaos followed. But you need sign nothing, commit to nothing, decide nothing. Simply rest. The lawyers argued. The judges pondered. The claimants waited. But you need do none of these things. The case is over. The story is complete. All that remains is sleep. Sleep now, as William Jennings sleeps in his forgotten grave. Sleep as the case files sleep in their archive. Sleep as the world slept through all those years while the case dragged on, oblivious to the legal machinations, concerned with other matters, moving forward while the case stood still. Sleep, and let time become irrelevant. Let the distinction between a moment and a century fade away. Let the story of Jennings versus Jennings become a dream, or less than a dream, just a faint memory of words spoken in darkness, of a tale told to help you find rest. The case is closed. The account is settled. There is nothing left to fight over, nothing left to claim, nothing left to do but rest. Sleep well. Sleep long. And when you wake, the Jennings case will still be over, finished, done, a thing of the past, a story told to carry you through the night. Rest now. The story ends. Good night.